Hello friends, today we are going to discuss about medical records. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at NIMANS, Bangalore. In this video, I'll be discussing about medical records, functionality, content, critical elements, do's and don'ts, ownership, retention, and ethical and legal issues with regard to medical records. Medical records are an essential component in the effective management of patient care. It contains various information such as clinical information, planning, providing, evaluating, assessment of patient care. It serves as an important tool to communicate information across the team members. Not only that, it helps in continuity of care of a persons who are suffering from any kind of illness. Medical record is an history of someone's health condition. Most hospitals and doctor's office either they record in physical form or else in electronic form. In some of the hospital during transition time, they will keep both electronic and physical records. Components of medical records varies across the discipline or else across that specialty. Let's understand. There is an important saying, it goes like this: verba volant scripta manent. That means spoken words fly away, written words remain. That means when you are providing a care to a patient, documentation is very essential. If you don't document, it is considered as you are not done. That is the essence of medical record. Let's understand the functionality of medical records. Why do we require? First and the foremost, medical records are required for providing effective clinical care. It contains clinical history, treatment history, investigation, diagnosis, treatment plan, recommendation, follow-up, and also the outcome. It also helps in communicating information with regard to treatment, investigation, need for any effective intervention across nurse and other team members, maybe physiotherapist, clinical psychologist, social worker, or any other team members. It also acts as a memory aid for the treating members during and also in follow-up. It is also an important administrative tool for billing, auditing, bed auditing, utilization of resource, and planning of resources in coming near future. It's an important record for health insurance. And for patient purpose, they require prescription, they require treatment certificate, at the same time admission and discharge certificate, disability certificate, medical certificate, leave certificate, or anything else with regard to welfare benefits. Medical records are the pillars for medico-legal purposes. It may be reporting to the police, consumer court, civil cases, criminal cases, court evidence, and so forth. Medical records are also essential for education and research purpose. Of course, with regard to epidemiology, reporting to the police or maybe policymakers with regard to various epidemic diseases. Hence, it plays an important role in policy making. But however, please remember, the primary purposes of medical record is patient care. Medical records are an essential element in the decision-making process associated with the care of any individual patient. Now let's understand who is responsible for documenting. The people who are involved in care, such as doctor, nurses, any person who is involved in care are responsible for documenting. So please remember, at the end of the day, the onus will be on the doctor. He can delegate this documentation to any person. If that person doesn't document, through vicarious liability, the doctor will be held responsible. Hence, whenever you delegate, please monitor whether that person is documenting. If he is documenting properly, he is doing it or not, or else is he writing something wrong. Hence, you have to be very careful. So, please remember, the final responsibility of doctor for documenting, it is on doctor. Hence, you need to see through the records, Check whether the nurses have documented properly, whether the physiotherapist has documented properly. All those things are very essential. Next question, when to document? The document has to be done as soon as the event is over. Suppose if I have provided any injection, please document it immediately. If you have done any minor operation, please document immediately. If you want to document later, it will be a problem because as the time moves on, memory fades and you will not be able to recall the minute details. Hence, you need to document at the earliest. However, during surgery, in any other procedure, when you are doing multiple procedures, you may not get time in between the procedure. However, during that time, use the audio recorder or voice recorder. You can dictate the notes in the audio recorder. Many a time, in corporate hospitals, these audio recording will be sent to medical transcripts. They will decode and write, and that will be finally approved by the doctor. Next comes says, what to document? What should be the content of the medical record? As per the Indian Medical Council, currently now National Medical Commission, as per the Regulation 2002, it has given certain important format. In Appendix 3, as per the Regulation 3.1, this should be the format. It starts from name of the patient, age, sex, address, occupation, date of visit, clinical notes, provisional diagnosis, investigation advised, diagnosis, advice for follow-up, and date. And this is followed by signature of the registered medical practitioner. But however, to summarize the content of the medical records, based on different branches and speciality of the medicine, the recording differs. But however, the skeleton of the medical record should be hospital ID, patient information, age, gender, weight, and also the contact details, demographic details, identification mark, reason for consultation, history of presenting illness, general physical examination, investigations advised and done, diagnosis, treatment, surgery if it is recommended, and if the surgery has occurred, you have to document that, advice and recommendation. These are the few important clinical variables which should be there. However, there are some other medical records which have been considered very important. Nurses' notes, if there are general physical examination forms, junior doctor notes, emergency doctor's notes, look for any arrangement, how they have arranged the file, whether they are properly arranged, numbering the pages, medical record files, check for the consent form, completeness of the documentation, discharge summary, and correctness of the discharge summary, progress notes, and follow-up notes. These are the essential components of medical records. But how to do the recording during follow-up? During follow-up, you need to remember this SOAP, S-O-A-P. S stands for subjective, O for objective, A for assessment, P for plan. What do you mean by subjective? Subjective is how the patient feels. Is he improved or he does not improve? His pain is less or more? How much is the improvement? The next one is objective. What the doctor thinks about the patient's condition. A, assessment. Assessment of the whether the treatment is working or not, whether there is a need for increasing the dosage or changing the medicine. Plan. Change of plan is there, how long the medication to be given, and when to call for follow-up. Next question is, who can know about the content of the records? That means this is an important aspect of any medical record. It talks about confidentiality and also who can access these records. Confidentiality or a privileged communication. Patient will report their pain, their suffering, their conflicts in the mind, and also whatever health problems to the doctors or nurses. Hence, these privileged communication should not be divulged to anyone. And that is the ethical responsibility of any healthcare professional, including doctors and nurses. Medical records need to be secured and kept in a place where it is not accessible to everyone. Hence, it needs to be prohibited for accessing these medical records. There are legal sanctions with regard to privileged communication if there is a breach of confidentiality. In many countries, The doctors have lost license, nurses have lost license for breach of confidentiality. Now, what are the critical elements of good medical records? That means, what is this so-called medical record which is good, which aids in communicating with other treating members, aid in coordinating care with other discipline, continuity of care, aid in informed decision making, logical explanation of decision taken is documented there, aid in risk assessment, auditing, aiding in medico-legal cases, planning, and management of follow-up. Further, the good medical record should be accurate, legible, date and timing of care whenever a caregiver has a touch base with the patient. It should be focused on the patient benefit. Nursing documentation, fresh treatment chart to be written whenever there is a treatment change occurs. That means if the patient is taking 6 medications and you have changed only one medication, in spite of that, you will do or you will rewrite the whole treatment chart fresh. Don't write change only the 6th medication, rest of the medication is same. Don't write that. That will cause miscommunication. Nurses may or may not give medication. That may harm the patient. And finally, final responsibility lies on the doctor, my dear friend. And every treatment, every documentation in the medical records needs to be dated, signed, and also you have to put your seal. And in the good medical record, all relevant clinical findings should be there. A record of clinical decision making chart should be made available. Logical decision approach should be made available. A record of the information given to the patient. Record of the consent. Record of any drugs prescribed or any side effect occurred need to be documented. Identity of the person who has documented in the medical record should be made available. Let's understand what are the do's and don'ts of medical record. First and the foremost, every time a person records something in the medical record, it should be dated and timed and signed. It should be legible. Make objective comments. Document if there is any non-compliance of doctor's advice, such as not taking medicine, not doing physical activity, not taking bath. Such compliance issue needs to be documented. Document oral communication, maybe phone with the family members of the patient, conversation with the patient, maybe in the OPD, or maybe within the veranda where the patient wants certain questions and it is answered, and the action taken with regard to certain advice. Document the informed consent. Informed consent is a process. The process needs to be captured. And also state the objection regarding care if the patient has raised, and also if the patient has asked questions, that needs to be documented. Further, the signature is very essential. But remember, in India, most of the litigation revolves around informed consent. Hence, my dear friends, especially for those doctors, when you document, don't forget to document the consent and the process of administering informed consent. What are the don'ts of medical records? Don't use abbreviations. Don't make offensive or sarcastic comment about the patient in the medical record. Don't use ambiguous terms. At the same time, do not delete, tamper, alter the medical records. Tampering the medical record is illegal, maybe a punishable offense in certain states. Make installment changes in the treatment should be avoided. Fresh orders for treatment should be written every time whenever there is a treatment change occurs. Making offensive comments, sarcastic comments about the patient inside the patient record, also making comment on the other doctors inside the record is not ethical. If there is any mistake in the medical record, what should be done? There are at times the doctor also will make mistake in writing information. There are times when doctors have written the medical record information from one patient to in another patient's record. What should be done? Corrections can be made, but it must be done in a proper way. It has to be done in such a way the appearance of the whatever it has been removed or cut off, a single line should be used. Cross out the incorrect information in a single line so that in spite of correction, the person who is reading should be able to understand what it is written. Don't tamper with that. The original information written should be legibly and can be read. But however, whatever you have stricken should be dated, timed, and signed. If possible, document why you are striking out certain sentences. Hence, think before you ink. What are the 10 C's of quality medical record? The medical record, especially when you are taking history, it should be client's own words. At the same time, clarity of the chief complaints of the patient should be documented properly. It should be in a chronological event. Completeness of the presenting symptoms is very essential. Causal factors with regard to patient's illness regarding stress, respirating factor, any other things need to be commented. Client's past history of treatment, confidentiality of history should be documented. At the same time, what are the confidential issues what the patient has raised should be documented. Consent for treatment need to be documented. Formulation need to be crisp, and comprehensive formulation has to be documented. Now the question is, who is the owner of the medical records? Invariably, many states and in many countries, it is the hospital, doctor, or the service provider is the custodian of the medical records. In some country, it is clearly stated that doctors are the owner of the records. But however, in almost all country, patient has the right to access the copy of the medical records. They may not be the owner of the original records, but all patients have right to access a copy of the medical record. Next question is, can we release the client's information to the public? This may happen whenever you are treating a celebrity. The celebrity is going through a tough time. He is admitted in ICU. There is a possibility press may ask you certain questions with regard to patient. He may be a well-known political personality. Should you give information to the public? Because public is in an anxious state to know what has happened to their leader or the celebrity. But you need to keep certain things in mind. The law usually specifies with regard to confidentiality. You need to be very careful. You can inform certain things to the law, such as if there is a medico-legal issues, such as injuries, poison, sudden death, abortion, such things need to be recorded as a medico-legal information and need to be informed to the police. Although confidentiality is a right, but however, it is not absolute. Every absolute right, what we discuss, have reasonable restriction that need to be known by every doctor. Further, authorities will notify regarding certain illnesses need to be notified to the administrative authorities. Events such as birth, death, fetal death need to be notified to the administration or else to the government. All these reports may be made without patient consent also. And this is a very important responsibility from the public angle. And the facility is also obliged to provide information in response to court order with regard to either civil matters or criminal matters. And if you are releasing any information to the public, please do take consent from the patient. If the patient is not in a position to give consent, please take consent from the guardian, especially if it is a celebrity, if it is a leader, and the public is asking for information, media is asking for information. In such a scenario, request the family member to respond to the media. Doctors need to avoid such situation. Suppose if the doctor wants to inform the media, please take a written informed consent from the patient's party. Without that, don't divulge. If you divulge information to the media, the family members can sue you in the court of law. Hence, be careful whenever you are releasing information to the public or to the journalist. However, in case of death, incompetency, or person is in coma, the information need to be shared to the family member and they will be the owner of this information. They will decide whether to divulge or not to divulge. How long these medical records should be stored? As per Indian Medical Council Regulation 2002 clearly said that in Regulation 1.3, it has said that maintenance of medical records should be for inpatient period for 3 years. All inpatient records from the day of starting treatment should be for 3 years only. However, outpatient records regarding that it is silent. And if there is any request is made for medical records either by the patient or authorized patient, family members, or a legal guardian, such information and record should be issued within a period of 72 hours, that is 3 days. Effort should be made to computerize all the medical records. But however, for the central government employees or the central government hospitals, Director General of Health Services has issued a notification with regard how long the medical records need to be stored. For inpatients, for central government hospitals such as Railway Hospital or else central government medical colleges like AIIMS, NIMANS, the inpatient medical records is for 10 years. For medico-legal registers, it is 10 years. For outpatient records, it is 5 years. It is applicable for all central government hospitals and central government colleges providing treatment for inpatient care. However, there are certain legislation which has mandated for medical records, and the doctor should know about this, such as Right to Persons with Disability Act. Under that, if you have assessed any patient, you need to keep the document of assessment. Of course, the disability certificate will be uploaded to the central server. The supplementing medical record should be stored for longer duration. With regard to Surrogacy Act of 2021, under Section 46, they have clearly said that medical records should be stored for 25 years. Similarly, in a Clinical Establishment Act, Registration and Regulation Act 2010, rules talks about between somewhere at least 3 to 5 years it has to be stored. Clinical Establishment Act, although it came in 2010, the state government has freedom to choose or not to choose, freedom to implement the same or not to implement, to modify or not to modify. Especially certain states have modified, such as Karnataka. Karnataka has modified this clinical establishment into Private Clinical Establishment Act, and this act was not applicable for government. There also, certain states have come up with their own rules with regard to storage of medical records. Similarly, under Income Tax Rules 1962, Rule 6F clearly says that the doctor in private practice are required to preserve the daily case register for a period of 6 months, and at the end of the relevant assessment year, invariably it crosses for 7 years, my dear friend. So, depending upon the various legislation, the medical records need to be stored for that purpose of that legislation. However, with regard to medical legal records, there is no clear-cut information, or else no law to say it has to be stored for so many years or so many days. There is no uniform legal policy or legal document with regard to storing of medical records. In our country, especially in India, the cases goes for 2 to 3 decades. It will be invariably in the district court or district consumer forum, state consumer forum, national consumer forum or commission, and finally it will be appealed to the Supreme Court. By the time that case is decided, it may go up to 3 decades. Should we store the medical record for such a long duration is the question. At this point of time, the medical legal experts say that we need to keep these medical records endlessly, or till the case is closed. However, one of the other way is to give a copy of the medical record to the court. That should be a certified medical record, which is submitted to the court. Or else, you can submit the original record and take the acknowledgement that this case file has been already submitted to such and such a court has to be taken, and that receipt can be filed, and that receipt should be kept for longer duration. Let's discuss about altering, tampering or forgery of the medical records. As per the medical records or hospital records, as per the law deals all application forms inside the hospital, medical case file, hospital bills, pharmacy bills, device bills, forms, prescription, hospital brochures, arriving or anything related to hospital records which is there as attender pass or postings of the duty of the doctors or nurses. All these will be considered as medical records or hospital records. Hence, we need to be very careful. Tampering with any of these records will be considered as illegal activity, such as adding certain information, removing certain information, destroying, falsifying, altering the facts, antedating. That is, backdating is one of the commonest illegal activity done by the doctors. Unauthorized entry, misleading, and forgery. These are some of the illegal activities done by various healthcare providers. Let's understand the legal validity of the medical records. Medical records are acceptable as per the Section 3 of Indian Evidence Act of 1872, which has been amended in 1961, that they are considered as a medical evidence records. These are considered useful evidence by the court as it has accepted that the documentation of facts during the course of treatment of a patient is genuine and unbiased. Erasing of entries is not permitted and it is questionable in the court of law. In the event of correction, the entry line should be scored, rewritten, and the date and time of the person who has done it and his signature is essential. However, if you are doing any forgery of the medical record, it is a punishable offense, defined under Section 463 of Indian Penal Code. What does it say? Whoever makes any fake document or incorrect electronic record or a part of a document with an intention to cause damage or injury to the public or to any person or to support any claim or title or to cause any person to share the property or to enter into an express or implied contract or with the purpose of committing fraud or that fraud may be accomplished commits forgery, my dear friends. Here, the intent matters. What is the reason for making the false document? The very basis of the offense is making of the false document with the criminal intent to cause damage to any person. It requires deception or mollified intention, my dear friends. Section 464 of Indian Penal Code describes about false document. A person is said to make a false document or a false electronic record if with a mollified intention to cause harm to somebody else. What is the punishment for forgery? Section 465 IPC describes punishment for forgery. According to this section, whoever commits forgery shall be punished with an imprisonment of a jail term, either description spanning over a period of 2 years, with or without penalty, and it is a non-cognizable and a bailable offense. Here, sometimes altering of facts also has been done. The act of altering is an instance of a document falsification, which is a white-collar crime, my dear friends. Now let's discuss about if there is a request for medical records from the police. Invariably, if there is any crime against the state and the police is investigating, they may ask for medical records. Invariably, the police wants certain information. They may not require the whole medical record at all. Invariably, they want to ask very specific 3 or 4 questions, such as what was the treatment of the accused or maybe the survivor of the crime. These questions are very specific. Hence, you need to be clear what the police wants. In any cases, especially legal cases involving cognizable offenses, Doctor is bound by the law to facilitate the investigation. What is this cognizable offense? Cognizable offense means able to apprehend the accused by the police without any arrest warrant by the magistrate. That means cognizable offense are those offense which affects the community at large. It is a heinous crime which is affecting the community. Hence, the police has been given the power to lodge an FIR, to proceed with arresting of the accused without the magistrate information or magistrate warrant. That is, the power is given to the police. Hence, in all those cognizable offenses where there is no arrest warrant is required and that offense affects the whole community, the police has a power under section 154 Criminal Procedure Code provides that the police officer has to receive an FIR relating to the cognizable offense without the magistrate permission. He can enter that information into general diary and immediate start he can investigate and arrest the accused. Take a request from the investigating officer whenever the police is requesting for medical records. Ask them, what is the offense? Take the request in writing. What is the offenses which is going to be charged? What is the seriousness of the crime? What they want to know. If they want to know only by the oral information, you can give the oral information to the investigating officer only. Otherwise, if they want a certificate, you can draft the certificate, especially in cognizable offense, and you can facilitate the investigation, my dear friends. However, there are court-based case laws are also being there with regard to medical records. Let's look into this one by one. If there is a false documents, there was a landmark judgment with regard to false document. In a landmark case by the Supreme Court, stated that the person is said to have made a false document. In the following manner it will be considered. He or she made or executed a document claiming to someone else. That is a false document. If he had altered or tampered a document, it is also considered as a false document. He obtained a document by practicing deception or from a person not in the control of senses. That is called as a false documents. Right to medical records. In many courts, especially in high courts, it has upheld many times the right of the patient to medical record is there. He can get a copy of the medical record and that copy should be certified. That has been written many times and it has been conveyed to the public at large. That means patient has a right to copy of a medical record. The patient's indoor medical case sheet is a property of the hospital and the patient has a right to get a copy, not the original record. That has been stated in some of the high court judgment. In case of a medical negligence, if the medical records are not submitted to the court by the doctor, the hospital and the doctors will be held guilty of deficiency of services for not providing the case records, not producing the case records. The doctor and the hospital can be considered as negligent by itself. It is the duty of the person in possession of the medical records to produce in front of the court. And if they don't do, the adverse inference can be drawn by the court against the person who has not submitted the medical records. If there is no proper documentation, the State Consumer Commission had given a verdict. It clearly said that if the case sheet are not properly maintained, no proper history is not documented, if there is no past history as documented, no investigation, even the consent forms are not documented, it itself can be considered as a negligence. State commissions have given verdict based upon how the medical records have been maintained, and if they are maintained poorly and the court is unable to come to any conclusion based upon the poor medical record, the court can hold the doctor and the hospital negligent. Hence, in one of the important case, the hospital was held guilty on the ground that the name of the anesthetist was not recorded in the operation notes. Hence, my dear friends, poor record means poor defense in the court of law or in the consumer court. No records means no defense at all. Hence, my dear friend, please remember, documentation of medical record is very important skill. To conclude, medical records are legal document. Hence, think before you ink. Document the communication. Whatever you have shared with the patient need to be documented, including the consent form. Communicate the documentation. That means if you have written or changed the treatment, communicate with the nurse that have made certain changes in the treatment, please go through it. At the same time, if the doctor fails in the treatment chart, most of the time it ends up in the court of law. And even with regard to consent form, proper documentation of the communication is not done. Not documenting at all. Verifying the nurse's notes is very essential. I have seen and given opinion in some of the important legal cases. As an expert, I have found the doctor has written something else and the nurse has documented the contrary. Invariably, the doctor will be held negligent. Hence, remember this. Whenever you go through a medical record, please verify whether the nurses have documented properly or not. Both the doctor notes and the nurse's notes go in the same direction. At the same time, timely documentation is very essential, my dear friends. This is about medical records, and if you have any doubts, please do leave questions in the comment section. Thank you very much for your valuable time. Stay safe.